Two live sessions are over, and you are very active in the live discussion forum. Lot of questions are there, and you have also shared questions in the sheet which we have shared with you. So what we will do now, the two types are there. Again, last time, whatever my observation was like this, that exam is like on Sunday, and obviously two types of like questions are there. One subject related question, and other is like a exam related questions are there, that hall tickets and the pattern and all other things. Okay, so what I'm observing that many of you have little bit kind of a concern about hall ticket or admit cards. So I have already passed this information to the technical team, so need not to worry about that. You will get that immediately. They will share it with you. Okay, so don't worry about the admit card. They are taking care of it. Now, second thing about the question paper pattern. It's like a MCQ type, so it will not be subjective, although there is a mini project, tutorials. Already we have done all things, right, in this course. So if we see the 12-week structure, we have covered all different types of intellectual property, and then we have covered the like mini project, then tutorial part, and then there is a practical like sessions, like it's like a workshop by the officials of the patent office. Then there is a trademark office, industrial design, semiconductor integrated circuit layout design, protection of plant varieties and farmers, right? So official from these all offices, you have already gone through that recordings, right? So now what is there, like you have to kind of you have hold on, huh. So you got pretty well idea about the practical aspects also, and you got a pretty well about the theoretical aspect. And in theoretical aspects also, you have like got chance to listen to different perspectives. Like I being here, like a teaching in IP, and I'm a being researcher, teacher. That perspective is there. Then technology transfer aspect, you have just got idea from Professor Purushothaman. Unnat Pandit sir has given you idea about that. Infringement and the different emerging issues, right? Then you have seen the conversation of Jere sir and Mohit sir, right? So Professor Rav has like he had shared his case studies, like it is like a first hand, like a primary kind of a thing. He has given you idea about how exactly the industrial design aspect is very important when you are kind of developing a product, right? So that different perspectives you have got very well idea about the different types of IPs, that is patent, trademark, industrial design, copyright, right? That one week is dedicated on these types. Then there is a semiconductor integrated circuit layout design. Then there is a like protection of plant varieties and farmers' right, trade secret is there, right? So geographical indication, huh? So you got a pretty well idea about this all 8 types of intellectual property, emerging issues in that particular. Then we have talked about open innovation also, that we are not like saying that yes, everything IP. No, there is open innovation also. And we are very well kind of shared with you the information about that, right? So you got that complete idea. Then you have seen the conversation between the examiners, patent office examiners, and they have shared with you the how exactly they are handling or a prosecution cycle goes in the patent office. You have seen the conversation with Professor or Dr. Prabhu, and he had shared you about information about how exactly that applications related to the protection of plant varieties and farmers' right, how it is taken care, right? Trademark related application, you have seen how it is handled. Preeti madam has shared with you the information about how exactly the examination about the copyright application form 14 is like that, right? So you got this complete idea about this particular details, right? And I hope now that examination is like just on this Sunday, so you have watched all the videos, you have gone through the e-content which shared with you, like that folder is there. On the discussion floor, discussion forum, many of your colleagues have asked you very good questions and we have given answers there. Probably you have got chance to go through that. I hope you have gone through the both live sessions already. We have like shared with the links I have already shared with you, and you know that discussion you have probably gone through, right? So this much, if you have gone through, probably the examination is like very simple for you. It is a MCQ type. You have done assignments also. 12 assignments you have done. So you got pretty well idea that 120 questions already you have solved. Examination, we have to just solve 50 questions. Huh? So 50 questions, 2 marks for each question, right? That is a scenario. So already 120 questions you have solved. You have to now just solve 50 questions in the examination, and it is a completely MCQ type question paper is there, right? So weightage is like this: 30% weightage is for the assignments, and 70% weightage is for the final examination marks. So assignment is like an open book kind of scenario, right? So you have answered that, as already I have shared with you. 6 best assignments we will consider, and we will consider like that final marks in your examination. Okay, so pattern is very clear, MCQ type. So you are very well like versed with that. You have already practiced that 120 questions you have already solved. So same pattern will be there, and you know about the like weightage, 30% weightage and 70% weightage. Based on that, the final marks will be allotted to you. That way the evaluation will be there. Okay, so I guess it is pretty well idea you got about the examination. The hall ticket I have already clarified, you need not to worry about that. Weightage also you got the idea. If still any other thing is there, you keep writing on the writing on that chat box, so I can take that question from there. Okay, so important concepts to prepare examination. See, I will suggest that you just go through all the videos. Everything is important, right? 30 hours, 58 videos are there, right? So I will suggest that you please go all the content, because it is a very rich content is shared with you. Try to complete that so that it will be easier for you for using it, exploring it. It's not for any examination. We are looking for that you are filing more patents, you are filing trademark, you are filing the publications. If you are in academic system, you are doing, but still we are seeing that yes, you are like actively using the different types of IPs. So please explore all the content, huh? Because I cannot say that importance is given to all. Obviously, it is like a equal importance is given to all the videos, right? And that whole content. So the coverage will be that like that. Okay. So I cannot say that this is important, this is not important, patent is important, copyright. I cannot say that thing. Okay. Okay. Now the next question is here, like admit card is the main thing I am observing, right? Next is like that. Kindly pour, Nidhi, Dr. Nidhi, she has shared this question. Kindly pour in some ideas for copyright for a non-technical background. I have already asked the students to register on copyright website. I want all my students to have at least one copyright registered in their name. Can I have a copyright for one poetry? Whom can I contact in case I need further assistance? So copyright, as you know, that it is a like one thing is there, thanks to Berne Convention, right? So because of Berne Convention, mandatory compulsory registration is not required when we are talking about copyright, right? But good thing, I'm just observing, being faculty, you are pushing students to use the portal, do the registration, and try on their own the copyright registration. Okay, for copyright registration, a fee is also like I can say it's a very it's a minute kind of a fee is there. So good, they will get the idea about that particular filing procedure. Obviously, they can explore the whole copyright website of Government of India, and they will get a very well idea about the Form 14, right? Now you are talking about some ideas for a that non-technical background. Actually, I will suggest, I will say that copyright is mainly for the, uh, if it is a like arts, so more towards going towards the arts background. And copyright, obviously, when we are as a science students and technology students, we are doing lot of publications, like research paper publication, we are writing books. But it is, if I consider academic system, what we are doing in the academic system, we are continuously kind of writing papers, we are continuously like we are publishing that sometimes poster publication is there, poster you are creating and you are taking participation in conferences, your participation in seminars, seminar reports you are creating, you're writing question papers, that answer script is there, right? Then you are like, maybe you're writing book. Huh? So this is like a normal academic activities, whatever we are doing, lot of kind of a copyright is created. Because when we are talking about a subject matter of copyright, what exactly it is? It is a literary work, it is a photograph, pantomimes, choreography, music, right? All this architectural work, all this is coming under the copyright. So when we are talking about any of this, so for example, you have mentioned about a poetry. So poetry is a literary work will be definitely getting the protection under the copyright. And without protection also, because of Berne Convention, you have already received that, right? But yes, when you do the registration, definitely it is a prima facie evidence in hand that yes, this is my poem. You need not to show the evidences if any infringement happens, right? So that is a great advantage, that if you have that certification, and if somebody uses it, especially this is very useful when you are talking about commercial activities. So commercial activities you are involved in, and if you are, so for example, you have a book, and that book, if automatically you are getting the eyes that the Berne Convention, because of Berne Convention protection, but you have kind of registered that Form 14, through Form 14, registered with that Government of India copyright like office. If you have done that registration, you have a prima facie evidence, very clear evidence that this big book is like, or the content is, whatever the content is there, is owned by me, because I have filed that particular like application for the protection of that copyright. And that becomes very important, because probably I'm just recollecting one movie clip also related to that. Probably it's like Drishyam, that he has like how exactly he has used the and it is a nice way. I feel that it's, yes, that much awareness is there, that in the film also they are taking writing a script or considering this IP. That is a wonderful thing. And nowadays you have seen that personality right is another kind of one of the IP, which is, we can say that one part coming in this purview only, that celebrities are aware about it, and they are starting now taking a copyright on the words also, like bidu and all that. That is trademark, especially that Jackie Shroff has recently filed that application for this word bidu. So yes, that awareness is there, but I can say that related to copyright, film industry is much more aware. They were having you have probably seen the parliament session in which Javed Akhtarji have done the conversation that he has like given how important it is to give the protection, and then you have seen the effect of that how exactly the copyright stringent, that implementation is like execution of rights enforcement, that has become like a little bit, we can say, stringent. It is not that stringent in academic system till that theft, copyright theft, you can see. But yes, it is good to do the registration, what you have seen. And I guess this much information, and then if you have watched the videos, is good enough for you to understand the concept of a copyright, right? And then there are neighboring rights are there, like a performance right is there, and then there is a broadcasting right. And these are, which are also called as related rights are there, right? Okay, now Mr. Suryakant, I guess you have given one question related to copyright, and then you want to answer for that. So I read that question. Probably it is related to patent or something like that. Mr. Suryakant invented water purification mechanism and filed patent for this invention in India. His patent granted within 2 years as he availed such service, that is a fast track service. Now he wished to take a patent protection in 15 other countries. Which route he can use? Conventional, PCT, cognate? And the answer is like, no, he will not get a patent in any of the countries, right? Because what is the reason? See the question. Question is what? That he has filed the patent. He has already granted, 2 years have passed, and within 2 years he has received grant. And you know that 12 months timeline is a very important. If you pass that 12 months lifeline, neither conventional nor PCT, any of the route is helpful to you, because you have already missed the bus, you can say. to file the patent in that other countries. And within 12 months only, you have to do that protection. So we have to be very careful when we are filing the patent, and if we feel that our market is in USA, our market is in Europe, especially when I've seen, when I was working with my clients, I've seen that in Europe, wastewater or waste management related patents, if you have seen, market is very good, means they are very active and they are taking very much care about that waste management, and that patents are getting, the gadgets related to that are getting a great market in this particular area, especially Italy. That particular observation, that is observation when I was doing the consultancy with MSMEs. So that is my observation. So you have to identify where exactly your market is, and within 12 months you have to file that. Now this question is stating that already 2 years are passed, right? And as 2 years are passed, it's 24 months are passed. So you have no chance. You have not filed PCT also. You have not filed conventional also. If you have filed PCT within that 12 months, then you have that 30 months timeline. So that is almost 2.5 years timeline is there. So that already like miss. So you cannot get the patent for that particular thing. Next is like this is the reason. Okay, I hope I'm able to clarify this particular thing. Next question is like I'm from Punjab. I will be an election notice during the weekends. Please ensure the exam date is not. Oh, okay. Sir, this examination date is like it's very difficult to change examination date, because it is before starting the course only we declare the examination date, and it's on, yeah, this is a little bit like difficult, and please, like, if we, and one more thing I can just share with you. If you have not able to give examination this time, you can give it with the next cycle. We are starting in July. So at that time also you can take the examination. That is like easily we can have this particular, that flexibility is there. You can do that particular thing. Okay. Okay. Next is like not submitted assignment number 11. Is it okay? Absolutely fine. 12 assignments are there. Out of 12, only 6 we are considering. And as I hope that remaining 11 are already you have submitted. So out of 12, out of 11, 6 best will be considered. Right? So I guess there is no issue. Vaishali madam, okay. So I guess I'm able to answer your query. Dr. Kaur, please excuse us that considering the examination time, we will not able to do that particular change. So I request you that in July we are starting the rerun of this course. So examination dates, I guess it is already came. So we will update the website, and you will get the idea about that particular thing. Okay, fine. Next is like yeah. One more question is related to the Paris Convention. Okay, so Dr. Nidhi only have asked this question. What she is saying is that she has shared with me, in this sheet actually, service mark related Article 6 of a Paris Convention. The sentence is like this here, the Article 6. Countries of Union undertake to protect service marks. They shall not be required to provide for the registration of such marks. Kindly explain. So yes, the sentence is a little confusing. I read it again. The countries of the Union. Union is that Paris Convention we are talking about, right? Undertake to protect service marks. Service mark is one of the type of a trademark. They shall not be required to provide for the registration of such marks. Kindly explain this. If you see the Paris Convention, if you have seen that, March 20, 1883, that particular convention is like done. It is amended several times. The latest, like in September 8, 1979 is the like latest amendment you can see. And it is independence of a protection of a mark in a different countries. In a sense, what it means, like as a citizen, two important things I want to clarify here with the Paris Convention in this context actually. So Paris Convention says that any individual will be treated as a citizen of that country. Okay, so what is the meaning of that? Citizen of that country means, suppose I am a like resident of India, citizen of India, and I go and file a patent application in USA. So USA Patent Office, that is a USPTO, should treat my application as if a citizen of a USA. So there should not be biases, there should not be any partiality, there should not be any kind of a privileges to that particular citizen, and I being Indian, I should not get that privileges. This thing will never happen. That is one thing. Second important thing is like this, that examination of IP, any examination of IP, I'm just talking general now. You take trademark, you take a patent, you take a maybe industrial design. So design and industrial design, that patent is there. Design patent in USA, you will call it as a patent. So anything if it is there, what exactly will happen? That it should not be dependent on the other jurisdiction. Means this should not happen. Sometimes people think that yes, if my patent application in USA is filed, I will get patent application easily in India. A very wrong concept, I will say. This is not the case. Every country patent office will do examination independent. There may not be any biases, definitely. Because what happens, example is like this. We have a very specific section 3, which does not allow the certain things which can be patented. But in USA, such kind of a thing is not there. Anything under the sun can be patented. That is a statement, right? So that is not the case with India, right? So here what will happen, that maybe you will get a US patent because business method patent USA grants. We don't grant that patent, right? You will get a patent for the dolly ship, but we will not get a patent like Onco mouse or Harvard mouse. So what is exactly is that we have like a section 3, we have section 4 that restricts certain inventions which will not be considered. So what happened here, that every patent office will have a different kind of examination system based on the guidelines of the Patent Act. Obviously, TRIPS guidelines are followed by every country. So here what will happen, that the sentence is like that, okay, if I get a patent application in USA, it does not mean that it will get granted in India. Or if I get application in Europe granted, it does not mean that it will get granted in India. So similarly about a trademark, similarly about industrial design, right? Or that particular any other type of IP if you are considering, right? So it says, means when we are dealing with the Article 666, it is like talking about that the filing and registration, it is like determined by the domestic legislation. It is a territorial right. We say that any IP is a territorial right. So obviously that country specific, and therefore although we get the PCT application, that report is there, like ISR, International Search Report, we do certain amendments. We have filed patent application in India, but we do certain amendments and then file in the USA to like match or to fulfill the criteria of that US patent office. So that minor amendments without changing the scope, without changing the invention, we can do that particular kind of a changes based on the ISR, which is a WIPO, that international PCT, International Searching Authority has given you that particular kind of a suggestions, kind of a signal says this is lacking, and then you can amend accordingly, right? Fine. So this is the meaning, like independent, that independent of marks is very important. That is what that Article 6 is talking about. Okay, Dr. Nidhi, I hope I am able to answer that question. Okay. Now, yeah. Next question is about the, teach share little study material for examination. Huh? I guess that all videos and then the content is good enough. Next is like a patent cost is about, Dr. Aparna Gunjal, she is asking. Patent cost is about 1,50,000. Are there any funding sources are there? So, yeah, means 1,50,000 professional fees. Yeah, some people are taking. So that range is there. Some are taking only 20,000, 10,000 to that 1,50,000 that patent filing fee is there. So the resources are like a patent facilitated system is there for startups, one thing, and Kapila program is giving you this filing fee, means 50%. That is that kind of arrangement is there, right? So that is their professional fee for individuals. I guess I'm not kind of recollecting any of the resources for that, but for startups, that facility is there. For academic institutes, Kapila under Kapila program, that filing fee, statutory fee related reimbursement is done, that is definitely there. Okay. Otherwise, I'm not recollecting any kind of a facility for handling that patent cost. Okay. So it's a scenario, but what I feel that 1.50, if it is a very complex patent application, then that kind of a costing will be there. In India, I'm considering India. Otherwise, it should be around 50 to 60,000 as a professional fee for filing, and there's some amount for a hearing and that IPR sub reply. It should be like that. Okay, then assignment submission, assignment related queries, I guess we have taken. Next is like this question is about a Google trademark. Mm. Above mentioned questions. Meera Prajapati. This question is like this. Something about a nice classification and Google for the question on Google trademark type. Based on my knowledge, after going through numerous sources, I found that Google belongs to a trademark type. Fanciful. Yeah, fanciful, arbitrary. It is arbitrary. It is a, actually Google, it is a, there is a long form for that Google word, and it is coined in that way. It is an arbitrary trademark. Okay, fine. Next is like a renewal of GI is done by association or individual for registered association, because GI issued to a particular product. So signatory is there, authority is there, association authority. They will be responsible for that GI renewal. But authorized users, they have to do their own individual registration, because two concepts are there. Authorized user, I being the member of that association, I get the right to explore and use that particular GI protection for that particular product. So I'm authorized user. So that also I have to that individual application is there, right? That you have to renew individually. But as a GI, that will be taken care of the association. Right. Next is like, does the mobile application code written in the language come under literary work or a computer software category? Okay. Source code. Source code, if we consider that, it will come under literary work. Computer program per se is not patentable, and computer program comes under literary work, and that can be protected under copyright. Okay, so I will suggest that mobile application that written in a language, it will come under the copyright mainly. Then again now that computer, you are writing as a you are writing language come under literary work or a computer software category. As I have told you that it is a program you have written using certain language. There are different languages. It will be considered as a, this copyright protection is easily given. Only source code you have to disclose. This is a like crux, and so many of people will not go for that protection. And the fact is that if computer related inventions, if it is there, if there is a technical effect is there, that can qualify for the patent also. So you have to just check that where exactly that, because I don't know exactly what that application is. It may be mobile application, but what exactly it is, I don't know. So you just think about the two things. Copyright application, definitely. That registration on that protection. But I will suggest if there is a technical advancement because of that particular thing, whatever the program is written, if it is given some technical advancement, please think about the patent also. Okay. So although that literary work, and then check that guidelines very carefully. Computer related patent guidelines are there. So kindly check that particular thing. Okay. Then I have BTech student enough. See the question, what he has written, who is, I just share the name, Sri Devi, that I'm guiding BTech student project. As of now, I felt it's good and worth enough to apply for patent. Shall I proceed in filing it, and at the same time, is it possible to publish it in a journal? Yeah, it is obviously possible to do both things. First file patent, maybe provisional, not necessarily complete also. Secure priority, take that 12-digit unique number, and then immediately communicate and publish that particular in a journal. Okay, so that possibility is there. 48 months timeline, application number is good enough for you to give the protection. You need not to wait for the grant. That is very important. So that generally this is one confusion is always there with the because criteria for PhD, many of the students who are doing research, uh, publication is an important criteria, and then patent you are talking about. So file a patent, do publication, so you will have both things together. No? Then there is a Sangeeta madam is asking, yeah, and Sangeeta madam, I'm very thankful to you that you are very active on the discussion forum. Lot of questions, that quizzes you have answered, then they have kind of helping the answering the questions of other fellow colleagues. So thank you so much. And your question is like, what are the technical, commercial, and social provisions to ensure quality assurance in the context of product or a patent outcomes when the licensing of a patent has been given to others for a commercialization, and the owner or a creator of a patent needs to ensure authenticity of the process or a product outcome. Okay, so I read the question again. What are the technical, commercial, and social provisions to ensure quality assurance when the licensing of a patent has been given to others for a commercialization, and the owner, see, whenever you are doing the technology transfer of your invention, it may be any technology, it may be process, it may be a product. You are the owner. So everything related to that particular technology, when you are dealing with the transfer of that particular patent or whatever it may be, like a trade secret it may be, so you have to anticipate the different possibilities, positive, negative, whatever it may be, and then accordingly you have to do the technology transfer process. Otherwise what happens that later on you have to kind of keep on like working on that particular thing. So you have to anticipate all the things in advance, and then you have to kind of take care of that particular thing. It's like not like once you have kind of done that particular deal, that contract is signed, and after that if you are like realizing that something like this is happening, probably that may not be useful. Okay, right. Next is like how does Kapila program works and which stream students are applicable as a patent agent? Okay, so yeah, so for a patent agent Kapila program, what I will suggest you na, you Tripathi sir, Swati madam, Swati Tripathi, what I suggest you na, that you just visit the website of a Kapila program, because lot of IP related kind of videos content is there, some programs, then fundings are there, so you just visit. It's like a IP literacy program, like Kalam IP literacy program it is. So you visit that and you just try to get the information about the details, because lot of kind of facilities and like related to IPR given through this particular program by Ministry of Education Innovation Cell. So I will suggest you to visit that site and go through the details. Actually, Institute Innovation Council and all this like parts are there, but you would check there. Related to IP, that agent, you just check that if it is a patent, science and technology background, science or technology background is a mandatory for that particular patent agent. For a trademark, if you are a lawyer, by default you are a trademark agent. So for that there is no any restriction. Any stream student can become a trademark agent, right? For industrial design, again, there is a mandatory science and technology, because patent agent is by default industrial design agent also, right? So that you have to kind of qualify that. So because industrial design is much more like a, yeah, it is aesthetic, like appearance of the product, but it is like one, many of many I can say that you can just check out that it is like patent agents are taking care of that, right? And for patent agent, the science and technology is mandatory. Because in jurisdiction, US jurisdiction, we call it as a design patent. In India, we are talking it as an industrial design. Okay. I'm a PhD scholar pursuing research in the visual documentation of a dance. I'm curious to know the Copyright Act is also applicable to performing arts, especially dance. Does the copyright also covers the performing arts? Again, in India, is there a copyright society for performing arts with a special focus on the dance? Okay. Okay. So performing arts, yes, it is coming under copyright. Then there is different societies are there. Like for songs, there is one. Then phonograms, there is a different society. For dances, as such, there is, I guess not. We have to check. There is one more, fourth society is like registered now. Previously, it was only three. So we have to just check, but I will just check once again because I don't remember anything particularly related to, because mainly choreography will come into that, right? So phonogram related is there, that songs related is there, right? That societies are there. Particular about dance, I doubt, okay? But let me confirm once. I should go through the details and I will confirm that on the forum. I will just answer that query. And but I feel that 99% particular related dance, nothing is there. Okay. I'm developing a documentation model as a part of my PhD work. Okay. Should I get it patented? Huh? See, documentation of a PhD work, if it qualifies the criteria of a patent, novelty, non-obviousness, and industrial applicability. If all this is like getting qualified, then only we can consider it for the like going for the patent application. If it is not like going into that, that fulfilling that particular thing, then probably it will not qualify for that patent filing. So that caution, that particular thing we have to think about that. Yes, that if it is section 3, section 4, and then the novelty, non-obviousness, and the industrial applicability. These things are important. Okay. Yeah. So in performing arts, especially arts like theater and dance, the production includes artists, choreographers, musicians, and writers who contribute in diverse ways. In this case, who possesses the actual right? Okay. Yeah. When we are talking about, for example, if we take a single, you have clearly like pointed out, we can just check one movie also. Take one simple example, say one Sanjay Leela Bhansali movie is there, say Bajirao Mastani is there. Actors are there, right? Deepika Padukone, then Ranbir Kapoor, they have their performers right is there, right? Then there is like a music, huh? Then the sets are designed like Desai, I guess he has developed that, Nitin Desai. So sets are developed, script writing is there, choreography is there, music is there, right? Dialogues are written separately, right? So dialogues. So you can just see that all things are coming into the picture, that each and every like aspect of that movie, if we see, it's a completely like copyright thing is coming into the picture. So what happens when such kind of activities there, which is involvement of a lot of stakeholders here, what will happen? Director is there, huh? So all this, they will kind of it will be kind of a work for hire like scenario will be there. In what sense? That for the contribution of them for performing, they are getting, say for example, actor is there for performing, he or she will get the some remuneration, some kind of amount is there, right? Some is like huge also, right? So it depends on the actor and actress, right? So it becomes a work for hire then in that sense then. And there is a contract agreement is there, like a contract is signed, and the whole rights are transferred to the producer. So here if any performing art is there, whosoever is like taking responsibility of a complete delivery of that final product, a final outcome. So final product of, say, that is like a movie is a final product. So here what will happen, he has to kind of completely do that activity and take a rights. That is very important. That is very important. Means if any mistake, if by mistake, if somebody like not take that right, producer if will not take right, that fellow can obviously claim the right over that particular thing. And again, if it is like a by mistake, by ignorance, by intentionally, we don't know. If somebody have taken it, it will attract litigation also. So at that time, again, the producer who has the owner will be responsible for that. Okay. So in that, what is happening? The contract is playing important role, and that contract will kind of decide on the who is the owner, and that way the transfer is done. I hope I'm able to answer this thing. Okay. Then, can we file patent without any IP expert? Yeah, if somebody is telling you 1.5 lakh, probably you will start thinking about this. Huh? Now, here the Sanjay sir probably have asked this question. So, if yes, then which precautions are required? Sometimes if we share some idea to IP expert, there may be chances of you have written that chances of stealing of that idea. For such type of cases, what should be the precaution? Okay, so yeah, so if this kind of unfortunate scenario and this unfortunate scenarios happen, you can file a provisional application. One thing, lab notebook is another important thing. Huh? So we have one dedicated session in roadmap for patent creation on lab notebook. Then we have published paper about how to maintain lab notebook, because that is very important aspect, that it works as a legal evidence, but to qualify it as a legal evidence, you have to take a certain cautions. So how you have to maintain that, how that legal notebook should be there. So we have a paper, that research paper is published. Probably it is a open access only, I guess. It's in Vikalp. So it is open access paper. You can just go through that paper. And one more thing is like that. I know this scenario happens because when I was doing practice, this happened, that stealing and all this happened. I mean, sometimes it's a very rare. It's very rare. It's not like rampant happening. But we have to take a caution. One thing you can do is a non-disclosure agreement. You can sign one thing. If you are not able to do provisional patent filing, also you can do the non-disclosure agreement, and then you can go ahead for the particular patent filing. So that is that one thing only you can do. We conduct a lot of workshops related to that particular patent filing drafting, and you can think about that also, right? So next we are planning in Mumbai. Actually, I'm planning that in June. So you can think about joining that workshop. It's a 6 days workshop, and it's a totally free kind of a thing for you. Okay, so you can think of joining such kind of a workshop. Okay. I will take one more last question and then I will wind up, because already it is a 15:54. Elaborate and explain the doctrine of equivalence infringement and willfully infringement with more appropriate examples. Okay. Okay, so here what happens many times, it's like a paraphrasing in copyright. So similarly in patent, if somebody kind of do the activity which is like similar to, means idea is like came from that particular activity, and based on that idea another product is generated, developed, and they have gone for the patent filing. So you have to prove, burden of proof is there to prove that yes, my idea and this particular idea, which is like you are thinking it is an infringement, you have to prove how it is an infringement. That burden of proof is there. If you can able to clarify that particular thing and access to that, and the similarities in between that idea and this particular idea, then probably you are able to kind of handle this kind of issues of that infringement. Okay. And willful infringement, so it's like a, you know that it's like a willful activity. And here with if you say that with appropriate example, you want to know about the willful infringement, how you can handle. Willful infringement, if it is that you know that this is your patent and this part is completely documented, this is completely used. So claim part, you have to focus on the claim part. You have to prepare a claim chart, mapping you have to do. And then by doing that particular claim mapping, you can prove that how exactly the infringement has happened. Very specifically, you can point out that particular infringement. Okay. So that exercise you have to do, and you have to show, and then the procedure, if you want to know the procedure further, one thing is like that willful infringement, if it is there, you can give notice first, and if that notice is not kind of attended, you can file a suit against that particular infringement. Okay. And jurisdiction wise, district court is a jurisdiction, not below. So you have to kind of infringement suit will go into the district court. So that way you can go for the taking actions related to the patent. Okay. So I guess I'm able to answer queries. Most of the queries I have clarified. There are a few more, but now it's like we are like coming to the end of that time is important. So what I feel that I have already told you that the content is there. You please go through the content. Out of 12, 6 assignments, and the final examination weightage 70-30 is there. Just remember that particular thing. Need not to worry about hall ticket. That will be taken care. Okay. So wishing you all the best for the examination, and do well in the examination. If you will not able to give examination because of certain reasons, like Dr. Kaur had said, you can take the examination in the next cycle also. Okay. So with this, we are coming to, I guess we can close the session, and wishing you all the best. And we hope that you will use the learning not only for this examination, please use this learning for your IP filing. Okay.